I don't want to butcher this question, but all I know about this question is when somebody asks me, do you speak Dutch, Christopher? Then I say, of course I do. And then I say, let me impress you. And I just get the throat ready. Huur gaat voor koop. I butchered it. I said it incorrectly.
It was beautiful. Huur gaat voor koop.
Huur gaat voorkoop. Yeah. Cilna, I believe you have a question on huur gaat voorkoop. See, it's really tripping me up. And the question you were referring to is around an agent, sale of a property, and where a rental agreement is in place in terms of huur gaat voorkoop. Can you please just elaborate on that a little bit more? And yeah, take us through a situation with this lovely phrase. It is Dutch, though.
It is very much Dutch. So, huur gaat voorkoop is the principle, and I know in a previous show we did huur gaat voorkoop in a lot of detail how it works, where it comes from, the whole thing. But the short version of huur gaat voorkoop is if there is a lease agreement in place, the right of occupation is already dealt with, and accordingly, if the property is sold, that right of occupation does not go directly over to that personal right, doesn't go over to the purchaser in its occupation form, but the purchaser can derive payment for the use of that right of occupation. This is called rental. So the lease agreement that's in place on transfer of the property, lease agreement will remain in place, and the purchaser of the property will simply step into the shoes of the seller as the landlord. You don't have to do an addendum. You don't have to do anything. You don't have to sign a new lease agreement. It happens ex lege by way of law on the moment of registration. That's the way it works. But now the question is, and this question I get quite a lot from the agents I work with. If I am the agent, I am mandated by the landlord. I have a management mandate, so I'm doing the day-to-day management of the rental. I'm doing the invoicing, and I am collecting rent on behalf of the landlord, and this is now my mandate. So what happens if the property gets sold? The tenant remains in occupation of the premises because of the principles of huur gaat voorkoop. If the landlord decides not to cancel and enforce his rights in terms of Section 45C of the Rental Housing Act, so the tenant remains in occupation. On transfer of the property, the purchaser then makes contact with the agent and say, listen, Mr. Agent, actually, fun fact, I have quite a big portfolio. I do my own rentals, or I have another agent that I've been working with for years. So I am going to move this mandate to myself or to another agent, but I am taking it away from you. And the question I always get from agents is that allowed? Because they make reference to the commission and to their mandate in the lease agreement. Now, first off, you can never, ever, ever, julle rarig, ever, be a party to a lease agreement as the agent. You can reference you, and in terms of the PPA and the regulations to the PPA, you need to specifically record in your lease agreement that you have a valid fidelity fund certificate. But more than that, you cannot be a party to that agreement. It's only the landlord and the tenant. You can reference your commission just so the tenant knows about your presence, but you can never rely on your lease agreement to claim your commission. It's as simple as that. The document that you claim that in is in terms of your mandate agreement. So the sale of the property, as much as huur gaat voorkoop means that the right of occupation may remain with the tenant, it says nothing about the mandate agreement. And the purchaser of the property is something brand new. It's a brand new person. In terms of our law and the majority of the free world, you have freedom to contract. You can never, ever, ever be forced to contract with a specific party. You can't have a sale agreement that says the purchaser must use my existing estate agent. It's simply not the way it works. It's as much as your estate agent may never, ever say this is the only attorney that you are allowed to use for your conveyancing. It's silly. We can't do that. It's not how it works. So the purchaser may cancel your mandate. And if you did not quantify your full commission properly in your mandate agreement, sadly, you will lose it. And this is why I always say, please separate your procurement commission from your management commission. A lot of agents absorb their management commission in their procurement commission into their management commission. The moment your mandate gets ended, you don't have anything to claim. If you separated your procurement, so your placement commission from your management commission, you can say, okay, Mr. Landlord, fair enough. You don't have to do that, but the landlord that mandated you, not the purchaser, the seller, if we cancel this agreement because you sell the property or you cancel the lease agreement, you will still owe me my full procurement commission. And in doing so, you protect yourself. So just keep this in mind, but the purchaser may definitely cancel your mandate. And the only party that will have to pay you is the seller, the landlord that instructed you, but only in as far as you guys have agreed to clearly in the mandate agreement. And this, my friends, is why you need written mandate agreements.
Wow.
That was that.
Thank you. That was all of that.
Also,
all of that.
so
Now
much.
you're done. You're done
That
now.
was that.
So just on that question, guys. So what I've seen practically, Cilna, I don't know if you agree, but the calculation of the procurement and the administration commission, it's really just a question of maths, guys. So it's not like but now it works so differently. You can still have a procurement, but you can even defer the procurement until the period of a year has lapsed, and then it gets written off. So I mean, you don't have to necessarily now charge a procurement when your competitors aren't. You just need to word it differently so that if the mandate ends a lot sooner, that you become that the person becomes liable for a certain procurement charge or a percentage of a procurement charge or pro rata, whatever it is. It is just maths though. So yeah, don't stress out. It is a mathematical way of looking at it.
Exactly.
Thanks, Cilna. Thanks, Bruno.